This is an unrelated announcement, but we are very delighted to have a media fellow here with us. She was in the room. Maya, did you leave? Where did Maya go? Oh, she was here a moment ago. She can confirm. So Maya Kapoor is our media fellow, and I think she's speaking next Tuesday or Thursday. She's with Mother Jones. But we discovered on the hike yesterday afternoon that Maya has hiked the entire length of the Appalachian Trail a couple of years ago. So she is willing to give a talk. Is there some interest in the group of hearing about this? So we're going to try and schedule her for Thursday or Friday at 4:30 in the afternoon, probably in this room or a similar room, to give a talk and show slides about hiking the entire Appalachian Trail and getting to Baxter State Park the day after it closed and being told she couldn't finish. So keep you on your So when Maya comes back, she'll be able to talk about it.
Thank you for that. Hi. Hello, everyone. My name is Sean Nolan. I'm the Vice Dean for Faculty at Vermont Law School. And I'd like to introduce our speaker today. Our speaker is Professor David Wirth from Boston College Law School. He teaches in the area of environmental law, administrative law, public international, and also foreign relations law. He has worked in a variety of positions before joining the Academy. He was the director of international, or the co-director of international programs at NRDC, and an attorney advisor to the Oceans and International Environmental and Scientific Affairs Department for the U.S. Department of State. He's a prolific scholar, publishing over 6 books, articles, and reports. And he's a graduate of Yale, where he holds an undergraduate degree. Law school, Yale, and then undergraduate and graduate degree in chemistry from Princeton, correct? Right. And in addition to being a great scholar, a great teacher, he's been here for 27 summers, so that's wonderful. He started teaching when he was 5, so there's that. In addition to all those great things, he's also a fantastic person. And he also has wonderful children who a few years ago I got to sit next to them at one of the dinners, so it was wonderful to get to know them. So he's also a good father, apparently, too. So with that, let me introduce David Wirth.
All right. Yeah, thanks for that very generous introduction. I particularly like the good father piece. I hope I have. I haven't hiked the Appalachian Trail, but I can say that my family was the very first one to cross that bridge coming into South Royalton when it was replaced. So we were the very first ones over the bridge, and my children were among the first to use the composting toilets when they were new. I was a little worried about losing my 2-year-old daughter but anyway, she's still around. It's not a problem. So thank you very much for the invitation to speak today. The topic that I gave Courtney was the safety of imported food. I discovered in preparing and sitting down to think about this talk that, to my horror, I had actually delivered this talk at Vermont Law School in a previous year, and I know that the audience for these talks is sufficiently loyal that you probably would identify the duplication. Also, I sort of scooped myself in the sense that I got a call from the Vermont Public Radio at Goddard College and did an interview in advance of this presentation, actually on the safety of imported food, but then I basically had said everything I had to say here. So you can find that if you're interested if you came here to hear everything you wanted to know about the safety of imported food, you can find that in a podcast on their website, which is here. So today, this is a hot topic. It relates to food. In fact, it's hotter than you probably realize because we're a little bit ahead of the curve in terms of the impact of geographical indications on the United States. It's actually related to the subject matter of the course that I'm teaching now, which is international trade and the environment. I just taught a course on the international law of food where we discussed this question, and as an introduction, I said to the students, well, what do you know about this subject matter area? These are the marks on champagne and on imported cheeses that identify them as such. And my students said, well, of course you can't just call any old thing champagne, and of course you can't just call a California wine that is sparkling champagne. And I said, well, where do those rules come from? None of them could answer the question, and most people, I think, don't really know where these rules come from. So that's the purpose of my talk today, as well as to move on to the next level, namely to suggest what these things might be useful for in terms of encouraging sustainability. This is a big area in the international trade agreements. Since the United States, in the person of Donald Trump, has basically pulled us out of many of them, it's not on the front burner in the United States at the moment. On the other hand, as I'll explain, farmers in Vermont and other places are feeling the secondary effects of these in terms of EU negotiations with Canada and other countries in regional trade agreements. So what I'd like to do is to first of all explain what they are, then talk about their relationship to substantive food safety standards, and then other label indications such as GMO-free. Vermont Public Radio, as I was driving in this morning, was describing a new rule that the federal government was proposing about labels for GMO-free that apparently has not received very much public support. So these are all very much on the public policy agenda. And then to discuss opportunities in the comprehensive economic and trade agreement between the EU and Canada and other regional trade agreements that deal with these. So first of all, what are these geographical indications? How do we know that champagne is champagne and brie is brie? The answer is briefly that the idea for these originated in Europe, particularly in France and Italy. They have been codified in European law through a series of directives that require all EU member states to recognize these geographical indications, for instance, the ones that are identified within Italy for Chianti wine, for instance, that the well-known rooster that you see on the label, that be recognized as Chianti throughout Europe. You can think, if you think about it, it's a fairly not easy thing to do, but it's fairly straightforward. This is a trade-related issue that falls within the exclusive competence of the European community, the European Union, and the European Union therefore has the capacity to legislate on it, and it has between 1992 and the most recent directive, important directive, is through 2012. These contain a list of geographical indications that are recognized throughout Europe. These are mostly, they apply to wines and spirits. Increasingly, they apply to cheeses and cured meats, in other words, other products. I was just discussing with Dean McHenry that I just came back from a brief stint at the University of Parma, which is the epicenter of geographical indications within Italy, if not within Europe, if not within the world. They produced Parmigiano Reggiano cheese. You're not supposed to call it Parmesan cheese. We'll get into why. The Parmigiano Reggiano cheese, as well as Parma ham, which is a distinctive product that has a cured meat. It's actually not cooked, which I didn't realize until I was studying there. So there are many familiar examples: cognac, sherry, champagne, Scotch whiskey, feta cheese, balsamico di Modena, which is in Italy and also right near Parma. The distinguishing feature, we seem to be stuck. Yikes. Okay, fortunately I remember this slide. The distinguishing feature is terroir, which is a French word. I actually have a French definition here. I will spare you my ghastly French pronunciation. Basically, it refers to the land and an assemblage of other characteristics associated with it, including the water, including the air. So for instance, when we went to visit the Parma ham factory, the windows, it was a very fancy, modern facility, and the windows were all open. I said, well, in this facility, why do you have the windows open? And the answer was, well, it wouldn't be Parma ham without the Parma air. So, and never mind that the windows are open onto a superhighway and there's lots of pollution coming in. It's still Parma air somehow. And if you look at the translation of this term into other languages, if you put it in your Google Translate, it will translate into English as terroir. I don't do French very well, but I do Russian. If you put it in and translate it into Russian, it comes out terroir, the same thing, but with a Russian accent. So the idea is that these geographical indications are very much tied to the land, which you probably already knew before you came in here. France had 593 of them in 2003. The UK, as a result of its membership in the EU, has gotten with the program and identified new GIs. One of the themes of this presentation is that GIs are taking off around the world, not just in Europe, but the European concept has been exported to other countries as well. There are 3 levels of protection within the EU system, that is the EU directives up through 2012. Protected designation of origin, which is the most rigorous. That applies to French wines, for instance, and then others that apply through traditional specialty guaranteed. So, for instance, I believe that Balsamico di Modena is a protected geographical indication, which is a middling level of protection in the EU system. Okay, if you were to take Professor Farrier's class, I think it's Professor Farrier, on public international law and ask how this system might be harmonized, the most obvious answer would be to get together a group of states that are interested in geographical indications and see if we can agree some standards. That has, in fact, happened, but through the Lisbon Agreement for the Protection of Appellations of Origin. And it turns out that the Lisbon Agreement has only about 27 parties. In fact, not all of the EU member states are parties. So that this idea of harmonization of GIs has not spread through what you might describe as the ordinary means of public international law. So for instance, in the United States, there's a great deal of suspicion about them as potentially operating as trade barriers within Canada as well. So for instance, there's a famous case in the Canadian Supreme Court dealing with the designation of Parma ham, in which the Canadian Supreme Court concluded that the designation Parma ham was a generic description and therefore could not be protected within Canada. So basically we have the EU as extraordinarily enthusiastic about these GIs and the rest of the world as being somewhat skeptics, as indicated by the low number of parties to the Lisbon Agreement. Not all states protect them in the same way, and this is basically the point that I just made, which is the Lisbon Convention has only 25 parties. I think it's now 27, including only 7 EU member states. Interestingly, I looked at this in the Russian system. This is becoming the Russians are getting enthusiastic about this, and they have bilateral agreements with other countries, and in particular Switzerland. They're protecting Russian vodka, caviar, and Siberian pelmeni, which are a kind of dumpling. They have a bilateral agreement with Switzerland that protects Swiss watches, chocolate, and Gruyere cheese in Russia. If you think about it, it's a little odd, a bilateral agreement just protecting a very small number. But in any event, the Russian example shows the enthusiasm that is spreading through the rest of the world for GIs. Okay, how do these work in the trade system? The answer is that they were originally identified as potential trade barriers, along with other forms of intellectual property, including patents, trademarks, and copyrights in 1947. If you're interested in more information about this, I would commend my course to you. You're welcome to sit in as an auditor, either this year or in a future year. But basically, the trade system originally identified all forms of intellectual property, including GIs, geographical indications, as a form of intellectual property. Over time, through the adoption of the agreement that created the World Trade Organization in 1995, they came to be accepted along with a variety of other forms of intellectual property as what you might describe as acceptable trade barriers. One of the reasons is if you think about the protection of films, which would be copyright, books, that sort of thing. This is the way I teach it to my students, that the actual CD on which Gone with the Wind appears is worth next to nothing. The real value of it is the creative energy that went into it. Similarly with trademarks, with patents on drugs, for instance. This was a big issue in the mid-90s, in the negotiations leading up to the creation of the WTO, and geographical indications were swept up in that as a form of intellectual property. And what I'm going to do in this presentation is to challenge that to some extent. What happens in the creation of intellectual property? It actually reifies, it turns into a thing, the intangibles, such as the film of Gone with the Wind, so that it can be traded without that protection. It's very difficult to assure that the property can actually be traded. Distinguishing feature is that they are monopolies. And it allows for trade in commodities that otherwise might not be tradable. And the WTO system has a very aggressive and effective form of implementation and enforcement through their dispute settlement process. So not too much progress through Lisbon and harmonization and coordination among states that might be interested in this. So the EU basically commandeered the energy on intellectual property, folded GIs into it in the mid-1990s, and now has protection under the agreement on trade-related aspects of intellectual property. There are too many words in this slide. I use it for teaching purposes, but the principal point is that wines and spirits receive a high degree of protection in the WTO system. Cheeses and cured meats, the Parmigiano Reggiano and the Parma ham, are still in play. And the EU is very much interested in selling this concept of GIs in this second generation of GIs applying to products other than wines and spirits, principally cheeses and cured meats. In theory, this would have been dealt with at the multilateral level, at the global level in the World Trade Organization, except that negotiations on a subsequent round of trade liberalization have basically failed. It's called the Doha Mandate, the Doha Agenda, and it has basically, most observers agree, is not going anywhere. And so the action has shifted to regional trade agreements. As I said, the U.S. has pulled out of negotiations has pulled out of the Trans-Pacific Partnership. Less well known, the negotiations on a U.S.-EU agreement have stalled. It was called the TTIP, a bilateral agreement on trading goods and also on investment. And the EU is now pursuing these GI protection through regional trade agreements, a theory that's called TRIPS Plus in the business. So they're being swept up in other intellectual property agendas. The US is currently quite hostile to them and so is being left out in the cold. And just to give you a sense of what's at stake, when Canada and the EU concluded a new agreement, the Comprehensive Economic and Trade Agreement, that includes protections for GIs, I'll describe it in a second, the US industry has said, oh, well, Canada is protecting these GIs and that disadvantages the United States because Canada is obliged through the TRIPS agreement to give effect to those protections to the entire world through the most favored nation provisions of the TRIPS agreement. So, in effect, these regional trade agreements or bilateral trade agreements with countries other than the United States can have effect here because other countries are required to recognize, for instance, the validity of the Parma ham designation. Just to give you a sense of what's going on in the Canada agreement, right next door to us, the EU got protection for more than 170 GIs for cheeses, oils, cured meats, and other products. So that's in addition to wines and spirits that are already covered. Canada got zilch, zero, nada, and is in the process of adding to its to this list of GIs, which in Canada and the United States are treated as trademarks. So the basic takeaway here is that the European Union is, with some degree of success, seeking protection for a second generation of geographical indications that are monopolies in negotiations with countries other than the United States. That, as you could see from the quote from the U.S. dairy producers, can adversely affect third countries such as our exporters. And my question is, what are these things good for? Given that they are proliferating in ways that appear to be gaining some momentum. This is an important slide, but the text somehow got left out. If you buy a bottle of wine that is protected, for instance, Chianti, or the example here is French Bourgogne wines, Burgundy wines, what exactly are you getting? The answer is a quality designation, but not necessarily an awful lot more. So, for instance, there was a study done of Bourgogne wines that found that all of them had trace amounts of pesticides, and some of them had 2 pesticides that were prohibited within the European Union. So, in other words, the designation of origin is not the appellation contrôlée, is not necessarily a designation of safety from a food safety point of view. The other example on this slide was a French vintner who raises what in France are called biodynamic wines. Here they would be called organic, so without pesticides. And he was in fact prosecuted under French law for his refusal to use pesticides, and which are required to comply with the specifications to obtain the certification under French law. So they are most definitely not indications of purity in the form of food safety. It's difficult to figure out exactly what else they are good for except to identify a particular terroir. So for instance, I looked at the code of practice for Parmigiano Reggiano cheese. It's not even specified what kinds of cows have to be used in order to produce the milk for the cheese. They can use any different kind, but so long as the milk is then processed in a particular way, then it qualifies as Parmigiano Reggiano. The point is that that's not necessarily required from my point of view, but the codes of practice don't necessarily track other public policy concerns in addition to the identification of terroir and the geographical indication of origin. So I wanted to look at how this compares with international harmonization on other issues besides just the geographical designation of origin. The answer is that there are not very many channels through which international initiatives can be harmonized with respect to food. One of them is the Codex Alimentarius, which is, you probably haven't heard of it. It's a wholly owned subsidiary of the World Health Organization and the Food and Agriculture Organization. It lives in Rome, and it is involved in the negotiation of minimum standards for food products, including labels. This is primarily of use to developing countries that they can then take these standards off the shelf. From the United States participates with less than complete enthusiasm in this process, because the thought is it's not that useful in terms of domestic regulation. So there are some attempts at international harmonization of food safety measures, but not very much. The other is that the international concern that has been expressed in the trade agreements about food safety, other than geographical indications, has been primarily negative, in the sense that the concern is for excessively aggressive food safety measures. So under the agreements establishing the World Trade Organization, which we study in my class, you're welcome to come audit. There are two major challenges, one against the European ban on 6 hormones in domestically manufactured and imported beef, another on GMOs, genetically modified foods and crops, in which the concern was for excessively aggressive attempts on the part of the European Union to presumably protect the public and the environment. There is nothing in these agreements that requires minimum implementation of any food safety standards whatsoever. So you compare that to GIs, which are a monopoly, and then the concern is for disciplining or assuring the absence of abuse with respect to food safety standards in the trade agreements. Then there are purely private schemes that attempt to deal with the safety of imported food by looking up the pipeline. The Food Safety Modernization Act of 2010 attempts to do this in a binding manner. That's the subject of the presentation you can hear in the podcast from Goddard, if it interests you. But the attention to the safety of imported food has lagged behind the enthusiasm for geographical indications on the part of the European Union. So these codex standards are transformed from a floor to a ceiling, in the sense that they limit the rigor of the efforts by particular states, such as the European Union, to protect their public and the environment. Two big disputes, hormones and biotech. One other point I wanted to make is about labels. If you think about the Chianti label, the Rooster, or the Champagne label, or Brie, for that matter, these things are quintessentially labels. What do they communicate? They communicate the geographic designation of origin. What else do they communicate? The answer is not necessarily a great deal. Right now we're seeing a proliferation of all kinds of labels, as to which the international standards are relatively few. Of this lot, which I'm sure you're familiar with, hormone-free, no hormones added, free range or cage-free, there is an international codex standard for organic. There is no international codex standard for sustainably produced or natural. In fact, in my class, we do a simulation negotiating one of those things. And with respect to GMOs, codex has basically punted, in the sense of saying that we're not going to take on this issue after a huge debate between primarily the EU and the US within codex over quite a long period of time. So basically only 3 labels that are harmonized through codex: nutrition labeling, organically produced foods, and GMOs. So the labels that have been litigated in the WTO, apart from GIs, have also, the attempt is to prohibit or limit the abuse of them for overreaching claims, not to establish that they meet particular minimum standards. There have been a variety of disputes concerning the labeling of sardines in the EU, labeling of tuna for protection of dolphins in its capture, as well as U.S. meat. So this is basically a summary of this research, or this analysis. If you look at GIs, geographical indications, they are protected through TRIPS, through the WTO, and through a variety of regional trade agreements as monopolies. There is affirmative protection to assure that other states besides the European Union recognize the validity of these GIs. By comparison, with respect to food safety standards and other forms of labeling, there's very little affirmative harmonization, number one, and to the extent that we have international cooperation of any sort, it tends to be focused on protecting against the abuse of labels that are overreaching in their claims, the excessively aggressive food safety measures. So, hang on. Which got me thinking about what are these things? Sorry, there's a mistake in the that's thanks to Mr. Gates and PowerPoint. I think I put a capital letter in there. What are they? They are a monopoly in the use of a label for largely luxury agricultural foods and products that identify the primary distinguishing feature is identifying an origin as certain location, terroir. If you compare them to other forms of intellectual property, I think there's good reason to question the underlying public policy benefit of them. So for instance, patents, with respect to patents, there's an explicit trade-off between the public policy of encouraging innovation and rewarding it through a monopoly, and on the other hand, assuring that the method, the art is disclosed to the public and can be made available as opposed to, for instance, trade secrets. GI is exactly what is the public policy benefit. They're said to allow some sort of aggregation of producers that then get the benefit of a particular market, which is about the best thing that can be said for them. So I just wanted to, by this presentation, get you thinking about the potential utility of geographical indications to accomplish other public policy purposes besides just the identification of the origin of the product. They're not necessarily correlated with food safety. That's the French Bourgogne wines that are contaminated with pesticides, or indications of quality. That's the French vintner who was prosecuted for refusing to use pesticides. On the other hand, they receive a very high degree of protection. What does that mean? There's no reason to think that GIs track expectations of sustainability and may in fact encourage overexploitation of local resources. To answer the question of the title, are Brie and Champagne sustainable? Not necessarily, because if you're giving a monopoly and market access to these producers, it may actually encourage the overuse of resources. There's a fair amount, a little bit of research that's being done in FAO, the Food and Agriculture Organization, about integration of considerations of sustainability into the codes of practice of the geographical indications, Parmigiano Reggiano and Parma cheese. It hasn't really gotten very much traction. As you can imagine, the EU authorities seem to be unreceptive to this idea. But there is a mild amount of research that has been done to encourage a virtuous circle in which the beneficiaries of geographical indications, in fact, are encouraged to or required to manage resources sustainably in order to gain the benefit of this monopoly label, and that provides a particularly aggressive form of market access. So my recommendation is that codes of practice for domestic and foreign goods should be reviewed and evaluated to determine their sustainability, and also that the trade negotiation should take into account whether that is in fact happening as a reward system to encourage sustainable trade as opposed to simply trade in goods that identify the geographical indication of origin. So I think I've used exactly my allotted amount of time. Thanks very much for coming, and I look forward to your questions.
I'll kick it off, David. It's
Sure.
an environmental audience. So what are the environmental implications of all of this? It sounds like there really are none, or they would be coincidental.
Well, one is to ask the question whether geographical indications are in fact encouraging overuse of resources. We don't really know the answer to that question, but the structure of the system suggests that might be the case. And then the other is to ask whether, given that these exist, that they're being aggressively promoted by the European Union, can we hitch a sustainability wagon to the momentum behind these GIs? In other words, can Canada, can Japan, which is now negotiating an agreement, a bilateral agreement with the EU, can the United States, under some circumstances, recognize these GIs conditional upon their incorporating provisions of sustainability in the codes of practice? I mean, I admit that under the current administration, that's probably not very likely. But the idea is to think about whether these GIs can be used to encourage sustainable trade, which is really, at least in my class, the big question that's facing us. The trade agreements are pretty good at encouraging deregulated trade, but whether they are fine-tuning trade in a way that puts a thumb on the scale of sustainability is a big question. So my proposal is, I don't know whether it's a big one or a modest one, but that the existing protection for GIs in trade agreements can be used as a vehicle to encourage sustainability across the board, much more so than they have been in the past. So there's no reason to think that they're encouraging sustainability as it is now, and they could be much more in the future. Yeah.
What about looking at trade a little bit more expansively and including things like tourism? So you got agritourismo in Europe that might be a little bit more beneficial if you look at it broadly.
Well, yes, I mean, agritourism and other non-product-based considerations are, of course, helpful. The question is how you build them into the trade agreement model. The trade agreements deal with trading goods, so those sunglasses that are sitting in front of you. The agritourism would be trade in services, and there are possibilities for encouraging more trade in services that are sustainable. There's been a lot less work done on what kinds of services are sustainable and what tests there might be. Even with respect to trading goods, there isn't an awful lot. But the point here is that these exist already with respect to trading goods such as wines and spirits, cheeses, and cured meats. We can take advantage of them from a policy point of view. I totally agree with you that looking at the sustainability of trade and services and putting a thumb on the scale there would also be helpful. Not clear exactly how it's connected to GIs. So for instance, one way to do it might be to include in the codes of practice for Parmigiano Reggiano or for Parma ham that farmers make facilities available for agritourists who want to come through and have a look. To me, that strikes me as entirely reasonable. It's not necessarily connected to the product as such. It's, in a way, even more iconoclastic than my presentation. So, but I'm prepared to go with it. Yeah.
I have a few questions, but I'm going to give you just one. So one of the things I wonder about these all the time is whether, I feel like there's two potential, there's like a pitfall, but there's also a possibility. So I wonder if these act as a barrier for smaller food producers, but then I also wonder if these have the potential for economic development. So if you think about a region that's possibly in need of some economic development measure, are these able to provide that opportunity to those regions to the extent that they can build the recognition for certain food products?
Yeah, well, the answer is not much work has been done on either of those, but in principle, yes and yes. So in theory, they allow, I gave a presentation along these lines in Canada related to the implementation of CETA, where these GIs are a really big deal. And the representative of the EU who was in the audience says, oh, well, you have to understand the original purpose of them was to allow small producers to aggregate and to sell their product through a cooperative system of some sort. Now that they are very entrenched with, there's a reason why I chose Champagne and Brie, yes, there's reason to think that it's only the big producers that are getting benefits. There isn't an awful lot of research on the economics of them in terms of local access, but there's reason to think that the system has ossified and there are considerable barriers to entry for new producers. Also, if you think about it, the codes of practice encourage, they require systematization. They require that the product be conformed to certain standards. And if new entrants have difficulty meeting those standards, then obviously they're prevented from getting the benefits. In terms of encouraging local development, the answer is yes. If we're giving preferential market access to a particular product, the question is whether there is a clearly identifiable relationship between the monopoly that's granted and the market access that's granted and the development opportunities on the other. And that's basically the crux of this talk, is trying to link those kinds of consideration to the benefits that are being provided without too much examination of what's really going on behind the scenes. So yes, they could be harnessed to encourage sustainability in services, agritourism. They could be harnessed to assure that there is sustainable development going on the ground and opportunities for community development. The answer is that they haven't much been. They've been taken as more or less a given and then sold by the EU in these trade agreements. Yes. Sorry, I'm calling on people. Maybe I shouldn't do that.
So I think this is kind of a simple question, but in one of my classes, in a research class, we're doing a project on food labeling as it relates to Vermont maple syrup.
Right.
Just like a simple hypothetical situation. And you had mentioned that the U.S. is kind of not very encouraging of these kinds of things. So what would the difference be of something like a Vermont labeled maple syrup versus, champagne? Kind of is the difference just that it's international scale or something like that? Is it the same thing? Is this a GI by calling it Vermont maple syrup?
Right. Well, the answer is that there are plenty of potential GIs out there. Vermont maple syrup is an obvious one, particularly here. The problem is that the U.S. legal system doesn't accommodate this very well. So GIs such as Parmigiano Reggiano are treated as service marks within our trademark system, which probably makes everybody's eyes glaze over. But they don't receive the same level of protection that they would within Europe. And so, for instance, the reason that the term Parmesan cheese is not protected is that it's become generic. Everybody understands Parmesan cheese as the thing that comes in the Kraft plastic canister with the green label that's produced in somewhere in the United States, as opposed to Parmigiano Reggiano, which is genuinely produced in Parma. So the level of protection in the United States is through the trademark system. That's the closest that we have, and it's not as generous, it's not as effective in protecting a monopoly of that sort as the European system. But exactly the process that you're describing is what's being promoted in regional trade agreements with Canada and with Japan. You can imagine other examples such as Panama hats. They aren't necessarily confined to food, although most of them are. So, I mean, to the extent that there are opportunities within the U.S., maybe the idea with Canada, at least, was to tap into those opportunities in Canada and create protections within Europe that are reciprocal to the ones that Canada is granting to the EU. The United States, from a policy point of view, has been a lot more skeptical about these because it tends to view them more as a trade barrier than as a beneficial means of protecting a particular mark. So the answer is potentially yes, the U.S. legal system isn't set up to accommodate that level of protection at the moment. Canada has, in fact, changed its trademark law to accomplish exactly what you're talking about. I think there is, yeah.
Thank you for your presentation. I have a question. Currently, China is trying to develop a legislation on a shared system to achieve the goal of access and benefit sharing of genetic resources and traditional knowledge under the CBD Convention on Biodiversity. So GI is one of the property rights system that often brought up by the scholars and policymakers that is one of the shared system that can achieve the goal of protecting genetic resources and traditional knowledge. But my question is whether these GIs in the UU and other system that actually, in addition to protect the monopoly rights, but also return the benefits to really protect the genetic resources and traditional knowledge.
Right. Well, one of the big issues with respect to traditional knowledge and knowledge that's gained from indigenous communities, for instance, is whether, for instance, under the U.S. trademark system, they are unique or whether they are generic in some sense, like Parmesan cheese as opposed to Parmigiano or Reggiano. But leaving that question aside, if the hurdle could be overcome, then perhaps this is a way to assure that there are some benefits to return to the communities that provide that kind of information in return for a monopoly that's being granted by whatever public policy system, whether it's a trade agreement or whatever. One of the points of this presentation is that the trade agreements have been much more effective at disseminating GIs than for instance, the Lisbon Agreement, just harmonization. But in principle, that's the question that was asked over here as well, which is can this public policy vehicle be harnessed for the benefit of local communities, whether it's economic development or whether it's returning the benefits of indigenous knowledge? The answer is, in principle, yes. In practice, not an awful lot because the debate hasn't moved forward very far. But all of these examples are examples of that you're coming up with, are examples of how the trade system can be harnessed in a way that encourages sustainability that it's not right now. All it's doing is assuring that there is the absence of abuse of labels and the absence of abuse of food safety measures, for instance. The one big exception, and the reason that this attracted my attention, is GIs, which get affirmative protection under the trade agreement. So yes, they can be harnessed for, in principle, for a variety of public policy purposes. They're not very much right now.
And we'll make this the last question so that people can go to class.
Hi, I just wanted to note that there is one other pathway to enforcement of GIs at the U.S. state level. And there's a sort of a follow-up to Vermont maple syrup and economic development. There is all the states have consumer protection laws. And in Vermont, there's an Attorney General's regulation that provides a framework for the use of Vermont in connection with food products, company names, the use of Vermont in a qualified way, like made in Vermont, processed in Vermont, and so on. And theoretically, anyway, and I think in practice, if there's a serious violation of that, the penalties can be pretty severe. So there was a similar regulation on GMO, and that got preempted by the feds, but the Vermont origin regulation has not been preempted. So just to note that.
Yeah, well, for just a response, thank you for that. I was not aware of that, and as usual, Vermont is ahead of the pack, well ahead of the curve.
Oh, sorry, it's not exactly a question, it's just a follow-up on that, and it's a matter of whether it's under consumer protection laws is it being protected or actually under trademark, because I think it's a different theory of law and how it's enforced and what those enforcement measures are undertaken.
Yeah, it's not a trademark regulation.
Right.
It's a consumer protection regulation. So it's focused on the accuracy of the labels and whether those would mislead consumers or not. That's the theory.
I took the comment to be saying it's not necessarily one or the other, but could be both. Okay, so thank you all for a very stimulating discussion. Glad to be here.